I'm going to go ahead and call this meeting to order. Kim.
Good evening, Mayor and Council. I'd like to hand this off to our Community Development Director, Sarah Copeland.
Good evening, everyone. I have the pleasure this evening of introducing our guest for this work session, Mark White. I've known Mark for over 15 years. I was thinking about that earlier today. When I worked in planning consulting, had the pleasure of working with Mark on a few projects throughout the country. And he is not only an urban planner, but also an attorney, has literally written the book on development regulations. It's called 21st Century Development Regulations, and is very knowledgeable about land use law and its relationship to planning, what cities can and can't do. So because we do so much redevelopment work, have a lot of projects going on that have a relationship to land use law, we thought it would be educational and useful for you all to hear this overview from Mark this evening. This is a little bit of a presentation in the round because this is also a joint meeting with the Planning Commission. We have a couple of planning commissioners here tonight. We want to encourage you to ask questions of Mark as we go, and I'll be keeping an eye back here if our commissioners have any questions also. With that, I don't want to take any more of your time because it's valuable.
That's
so
okay.
I'll turn things over to you.
Thank you, Sarah. Thanks for the nice and the generous introduction. I am the senior partner with White & Smith, LLC. We are in Lee Summit and Charleston, South Carolina. Like Sarah said, we do work all over the country. I've got a few clients in Missouri and over the years have worked with Missouri land use law, land development law, and so have some background on, the parameters of local authority, which is really important here in North Kansas City, where you're a third-class municipality. So it's not like being a home rule city where you can do whatever you want unless the state says you can't. Here, you can't do anything unless the state says you can. You're subject to your local enabling legislation. So it's really important when you look at your comprehensive plan and look at your policy initiatives, things you want to do that you really consider the scope of your authority under Missouri land use law. And like Sarah said, I can't help myself because I love talking about this stuff. I put together a presentation that might be too long. I'm going to try to get through it as fast as I can, but I have no ego, so feel free to interrupt if you have questions about anything, or if there's just something you've got a burning issue about zoning or land use law in your mind that I haven't covered, just pipe in, interrupt me, and feel free to ask questions. I enjoy having that kind of dialogue. So when Sarah mentioned, presenting about land use law, this is something I also taught as an adjunct professor at KU's urban planning, Master's in Urban Planning program for a while. And I taught land use law, and I always told my students at the very beginning of class, here it is in a nutshell. This one slide here probably are most of the bullet points you'll need to know about land use law. Now, the details and how you apply them can be quite complicated, but basically it begins with the comprehensive plan, which you've got in 2016. You adopted a brand new comprehensive plan, and in Missouri, that's your official statement of long-range land use policy. And it also serves, and I'll talk a little bit more later, it's sort of a basis for making land use decisions that if, we hope they don't end up in court, but if they do, it's something where judges are going to defer to what you did. They're going to recognize that you took the time to come up with long-range land use policies, you studied things, you collected data, you met with the general public, and there's a basis for what you're doing. The second major aspect of land use law is the issue of authority, like I mentioned earlier. You're a third-class municipality, and that means your authority is constrained. Now, the authority you've been given under Chapter 89 of the Missouri statutes, there's a lot of things you can do under that, but that lays out the scope of your authority in Missouri. And there are also times too, where the state can come in and preempt what you can do. My oldest client's a rural county in north central Missouri, where 20 years ago I wrote a health ordinance that regulates animal feeding operations, which gave them very broad authority to establish setbacks, set bonding requirements, and et cetera. And a few years ago, the Missouri General Assembly stepped in and said, well, you can't do that anymore. You can only regulate the way DNR regulates. And so they preempted us to a certain extent. So that can happen. Then the third major bundle of issues is the whole issue of constitutionality, and I'll get into some of those tests. So both the federal government and the state of Missouri have their own constitutions, and the Bill of Rights in both states set out some recurring issues that come up in land use law. Due process, property rights, that's taking, how equally you treat people and applicants and so forth, that's equal protection and so forth. And then the other major issue that comes up a lot, and I'm not going to spend a lot of time on this one unless somebody has a particular question, the whole issue of nonconformities and vested rights, that when somebody's established something lawfully and they've been in business for a while, you can't just come in through your regulations and force them to shut down. They're considered, the informal word for that is grandfathered. They're grandfathered, and they can continue to operate the way they were before, and there are limits on how you can deal with that in Missouri. Now, in build-out communities like North Kansas City, that sometimes is an important issue because you don't get a lot of new you're not going to get a lot of new subdivisions like we have out in Lee Summit where I am, where we had, hundreds, if not thousands of acres of undeveloped land and a lot of new subdivisions, new residential development and so forth. And that's a lot of the activity that happens in front of their planning commission. Here, you have existing buildings that sort of recycle themselves over time, and they change uses and so forth. So if you change setbacks or more importantly, in your code, building design standards and those sorts of things, sometimes that can create nonconformities. So I'm going to start by talking a little bit about authority. And it's we call it the creature concept. You're a creature of the state of Missouri. North Kansas City exists because the state of Missouri set up a way to establish cities and municipal governments, and that was done some time ago. And you exist at the pleasure of the state of Missouri, and therefore the state gets to tell you how you go about doing your business. The flip side of that would be home rule. If you had a home rule charter, you could do anything you want unless the state preempted you, came in and said you can't do something a certain way. Otherwise, you could do pretty much anything you want. And the concept of limited authority as it's applied to levels of government like North Kansas City is known as Dillon's Rule. And Dillon's Rule says you can do anything that the state expressly grants you the authority to do. So if it's laid out in explicit terms in the statute, or if it's necessarily implied from those words, you can do that. But you can't do anything else. You're limited to that delegation of authority. Like I mentioned, Chapter 89 of the Missouri statutes sets out the zoning enabling authority for municipal governments. And there are a lot of things you can do. If you go to the 89 point, and I'll talk a little bit too about some of the, there's not a lot of progressive, stuff in Missouri's statutes. We've had what we call the Standard Zoning Enabling Act for a long time, but even within the four corners of those, I think there's a lot that you can do, and it looks like you took advantage of some of that when you updated your zoning ordinance a few years ago. And then there are general police powers. So sometimes you have the authority to do things. You can turn to other parts of the statute. Maybe outside of zoning, there may be things you can do to maybe indirectly or incidentally regulate land use and land development. One example is, how we regulated these animal feeding operations in Livingston County a while back. We didn't turn to the zoning statute because the court said we couldn't. We turned to the health statutes, 192.300, and they delegated that authority. That actually went to court, and the court said, yeah, you have the authority to regulate animal feeding operations under that. And then, of course, the state came in and swept the rug right out from under us, so that can happen. I mentioned under the Standard Zoning Enabling Act, that's the model Missouri's had, and it's had that model since I believe, the 1920s or the 1930s when it was first passed in Missouri. There's been amendments from time to time, but that's still the model we have in Missouri, where you have the power to regulate uses and buildings. Uses is what most cities seize on, and divide uses by districts, and that's conventional zoning. And in those districts, you have minimum setbacks and maximum building height and so forth. And all your regulations have to be, it says, in accordance with a comprehensive plan, but it doesn't tell you in the statute what a comprehensive plan is. So it's pretty much, you could designate any document basically as your comprehensive plan. In fact, there are courts in Missouri that have said your zoning regulations themselves can furnish your long-range land use policies. And then there's something called the Standard Planning Enabling Act that deals with public improvements, and it gives the Planning Commission some authority to review public facilities that come before it, and then there's an override provision in there. So if you do this comes up sometimes with capital improvements programming, or maybe a major utility that wants to build something, and planning commissions can invoke their authority to review those things. It's rarely used. A lot of people have forgotten it's there. But that is authority. In fact, I was hired as an expert witness to testify on a case that came out of the application of the SPEA as it applied to a utility peaking station years ago out of a Missouri county. So, but that's one of the few cases I've seen anywhere in the country that really get into this. A lot of states in other places have adopted more up-to-date planning legislation where they'll say you either can have a comprehensive plan, or we'll give you financial incentives to have a comprehensive plan. And here are the elements of a comprehensive plan. You have to have a land use element. You've got to have maybe a conservation element. And it'll go down the list and tell you, what has to be in those. Some states like Florida have state level review, which if I were a planner, I'd find that burdensome. We don't have that here. You can do what you want in Missouri. But those are also sometimes can be good models of maybe if you're doing a checklist of what you want in your plan, maybe that's something to look at sometimes. But you do have a lot of authority here in Missouri to do what you want. And like I mentioned, the plan kind of is it's your long-range planning policy. So it's the basis for what you do in zoning and in subdivision regulations when and if you get a subdivision plat application or an application to vacate a street or something and turn it into something else. The comprehensive plan is maybe a shorthand way to put it is your constitution for land development. It's probably what you should look at first when you're amending a zoning ordinance. And if somebody asks for a rezoning or something, you look at your future land use map, you look at those policies, and you weigh those against that. So it's your vision. And it also can provide findings and a basis for what you're doing. Yes, sir. Did you have a question? Yeah.
Thank you. Calling a constitution brings to mind the question of, once you establish a comprehensive plan, can you amend it without having to redo the whole comprehensive plan?
Yes, you can amend individual pieces of it. You don't have to do the whole thing at once.
And that can be done at any time then after
At any time.
it's adopted?
Certainly.
Okay.
Yeah, the state has some, I think there's a process in the statute for notice and hearing and et cetera. It's not real burdensome, but you got to follow that. But
Yeah.
that said, the statute doesn't say you have to do the whole thing at once. So, yeah, there's individual pieces you can do it in. Good.
Thank you.
Thank you. Like I mentioned, other states have adopted different models for comprehensive planning. Our state, like Texas, like some others around the country, still has a Standard Zoning Enabling Act where again, if you didn't have that 2016, I think it's called the master plan, which is your comprehensive plan, and somebody asked for a rezoning, the neighbors showed up in court and challenged it and said you shouldn't have approved the rezoning, and it was arbitrary, it violated your comprehensive plan. In the past, Missouri courts would look at your zoning regulations themselves. They'd look at the purpose statements, things like that, and they'd kind of read into that a comprehensive plan. Most cities and the more forward-thinking ones like y'all have adopted separate documents that have comprehensive plans. And other states again, have either prescribed what goes into it. Some states have very strict what they call consistency requirements, which means your zoning regulations have to absolutely line up with the comprehensive plan, and people can go to court and challenge your zoning if it doesn't comply. And, you know, there's some pretty dramatic examples of that. Florida's an example of that, where somebody built some duplexes in a district that didn't allow them in its future land use map, in the comprehensive plan. Actually built the duplexes, leased them out. It got challenged by the third party, went up and down, you know, it was appealed, and it got set back down, then it got appealed again. Somewhere in the middle of the court ruled that it was, the zoning was inconsistent with the plan, and they had to actually tear the duplexes down. That's how strict it is there. We don't have that level of strictness here in Missouri. It's a little more loose. It's a very good idea to follow your comprehensive plan, but courts aren't always real strict about that here. There's also some other interesting applications. This came out of southern Missouri that had an interesting, like you all do, they had an interesting zoning code that had a permit system that assigned points to different things. And one of the things that they required was before they issued a zoning permit that had to be consistent with the policies in the plan, and denied one that went to court. And the court upheld denying the permit because it was inconsistent with the plan. So, you know, local governments in Missouri, in your zoning ordinance, you can be real tight about that if you want. But as a matter of policy, you may want to be more flexible. So, but that's an option for local governments in Missouri. I'm going to talk a little bit about the two main tools for implementing the plan. The first one is zoning, and that's going to be the most important tool for North Kansas City because you're principally built out. The second one, subdivision regulations, and I'll talk about that real briefly because, like I said, I'd be shocked if you got very many more plats coming through the door in a community like this. So there's several models of zoning, and the first one is what's known as conventional zoning, and that's where you assign different land uses to different districts. And you've done that, although I'll talk a second about, you know, the form that or the model that North Kansas City has adopted, but you got some of that here, where in some districts you can only do, in most communities, single-family detached residential, and others you can go all the way up to heavy industrial, so it runs the continuum. And the reason you assign all those different uses to different districts is to, you know, keep incompatible uses away from each other, or to avoid nuisance-type situations like here. You've got the crocodile farm right next to the skydiving school. You don't want that to happen. You know, so we want to avoid situations like that. Although communities around the country, you know, in the early days of zoning, that was considered quite a progressive and a neat way to do things. But communities found that if you want walkability, if you want complementary uses close to each other, it kind of became a problem. And the metrics in the districts sometimes became a problem. So setbacks and things like that. Some of the uses you designate can be permitted by right, and others you have that are conditional. So they go, I think, through the Planning Commission and the City Council. You make findings of fact and conclusions of law, and you approve it. And sometimes, based on the facts and circumstances of that case, you can attach conditions to them. One interesting thing about the role of city councils like y'all in doing that is normally you're a legislative body. Your main role is to approve legislation, ordinances, long-range things. When you consider a conditional use permit in Missouri, and courts have said this over and over, you take your legislative hats on and you put your administrative off and you put your administrative hats on. So you're almost acting like a court. And you have to base your decisions on evidence that's in the record. But at the same time, on the flip side, you have some discretion too, based on what that evidence is and based on what the criteria are for approving a conditional use, you can attach conditions. So it gives you some case-by-case discretion. And then you have conventional metrics in zoning, minimum lot size, typically minimum setbacks. Most of the setbacks are minimums in conventional zoning. The thought was you want buildings to be fairly far from the street, so in case we want to widen the road later, we can do that to minimize noise and those sorts of things, or maximum height, maximum lot coverage. The idea is to keep things nice and, avoid dense and intensity and that sort of thing. And that was the way to keep things conventional. But a few years ago, I think you all went through a zoning update process, and I imagine you probably looked at different ways of doing things based on your old zoning ordinance, and you adopted something called form-based coding that you built into this. And what this did was it took advantage of something that most places around the country have kind of forgotten that still lives in the Standard Zoning Enabling Act, and that is you're not just limited to regulating uses by district, you can regulate buildings by district. And what y'all did is you defined different building types, both in terms of how far they are from the street, and sometimes you change the metrics where the buildings, instead of having to be a minimum distance from the street, you want them closer to the street. You want them oriented. You want that frontage facing the street to make it walkable, to create a nice streetscape, to make it an interesting walk for people, so for somebody who wants to walk to a corner store or something like that. So you got away from sort of the rigid nature of the old way of zoning and created different building forms by district, and you illustrated them. And so you did a good job of that. And, this is an example of the difference between that both of these uses here could be considered duplexes. They're two distinct dwelling units that are inside the same building, right? And it's one story. But the one on the left, that's a duplex. This is a community in Virginia where I started to write the zoning code a few years back. This wasn't built under the zoning code that I wrote. I want to make that clear. But when that duplex was built, what the community did was they said, we don't like the design, and their tool was to no longer allow duplexes in that zoning district, which seems a little extreme, doesn't it? Y'all did the smart thing. You said, well, we don't want duplexes that look like that. We don't want it, the entire frontage to be a garage. We don't want the entire front yard paved over. We want prominent entryways and things like that. What y'all did is said, well, here's a duplex, but this is how it's going to be designed, right? We're going to have a prominent frontage. The frontage is going to orient itself to the street. We're going to put the cars in the back through an alley and that sort of thing. And it looks like those single-family homes right next to it. And so you got a little more prescriptive about what the physical outcome of development is. And that's why we call that kind of code a form-based code. You're concerning yourself with physical form and not just use. And so that raises a couple of issues too. And this is a very, that's a very state-of-the-art way of regulating development around the country. And it looks like you all did a very good job with that. You've got some things in your plan, though, that are kind of interesting that still address what happens inside the unit. And it still addresses the impacts of development, which is what conventional zoning was supposed to do. And one is to increase home ownership rates, as I understand it. And I don't know what the exact number is, but it seems to me, I think most of your dwelling units here are rental, which is fine. Usually, they're more affordable and that sort of thing. And they're permanent, they're permanent residences for people, at least for, until they sometimes move up and buy something. But the city's comprehensive plan talks about not just attracting new residents, which you could do with any form of residential development, but also to increase your home ownership rates. And as I understand it, you're sort of struggling with, are there things we can do through zoning maybe to help make that happen? It's interesting. I found this issue to be fascinating because that duplex image I showed you, the one on the left could be a rental unit, right? It could be 2 units on the same lot, each of which are rented to the occupants. Or there could be an imaginary lot line that separates both those units. They both live on, both those units could be on separate lots. and the lots and that part of the building, like a condominium form of ownership, could be sold to the homeowners. And so same exact use, same exact building form, just a different way of occupying things. What conventional zoning law says is that what local governments can do, especially local governments with limited authority, under zoning, you can regulate land use, you can regulate building form, but you can't regulate form of ownership. This comes up a lot in the reverse. In the old days, and actually it's happening a lot now because all over the country, communities here in Kansas City, the suburbs of Kansas City, especially with COVID, are struggling with the cost of housing. And a lot of communities around the country have seen apartments convert to condominiums, and a lot of communities tried to restrict that through zoning and said you can't, you can have an apartment in this district, but you can't convert that apartment to a condominium. And what courts have said almost uniformly in every state that that's come up is that you can't do that. And the reason why is a condominium is not a use. A condominium is a form of ownership. And through zoning, you can regulate land use, but not ownership. So that building is a multifamily building. And you can restrict each of those dwelling units to one household, for example, but you can't say how that household owns or whether that household owns or rents the unit. When I look at your land use policy, it's interesting because it's sort of the reverse. It sounds like y'all would maybe want to encourage condominiums, maybe, and you don't want to get rid of rental units, but you'd like to see more of the condominium form of ownership. So, yes, sir.
One thing, I don't know if you were made aware, I only think there's one person sitting up here that actually was involved in that master plan. So some of the things that are in there, not all of us tend to agree with, but I'm curious to clarify what you just said about if something is zoned for R5, I guess we would have here, which would be multifamily. We can't tell the builder whether it has to be an apartment or a condominium. Is that right?
Correct.
Okay, because we've had apartments going in where a lot of the public response was, well, you should have built condominiums, and we couldn't have made that rule anyway.
Right.
So like if we respond, that was out of our hands. Is that correct?
That's the way I understand it. Okay. Now, that said, I did a lot of research this weekend preparing for this to see if courts have applied that form of ownership to that apartment versus condo.
Sure.
I haven't seen any decisions that explicitly address that, but, it does, I think it's the same principle, right? And you've incorporated that. What you've done here is the way I typically write my codes too, is a multifamily building is a multifamily building. It doesn't matter whether it's apartment or whether it's a condo.
Okay.
So I think you're doing the right thing if that's your response to the public. Yes, sir.
Since most developments ask for various kinds of benefits from the city, is that a way for a city to, in fact, require some of these things, such as condominiums versus apartments, as a condition for granting those benefits?
Yes. I want to make this clear. Mr. Saper and I didn't plan this in advance. But that was the most beautiful setup I could have asked for this next slide. So that's exactly the point I was getting ready to make. So I'm glad you're paying attention. My students in planning school would have been asleep by now, but you're paying attention, so I appreciate that. Yes, and I put this slide together to kind of show you the continuum of discretion and maybe some things you can think about if that, and I know not all of you were here when the comprehensive plan was done, so I don't know if that policy is still supported or if that's something you want to refine maybe and make it a little more detailed and kind of get into the how-tos. But what I've been talking about is the by right scenario where you're looking at the zoning district and what uses are allowed by right. And, you can say we allow multifamily in this district and you can allow it by right. And you can also allow multifamily, in some districts as a conditional use. So they'd have a process to go through and you could attach conditions. I'm very doubtful as to whether one of those conditions could be either through application of the standards in your ordinance or whatnot. I don't think you could condition that on, well, we'll approve you, but you have to reserve these units as condominiums. I think that would be a difficult thing, I think, under Missouri land use law. But one thing you might want to look at too, and what I've done a lot of, and I'll show a few slides on that next too, is kind of the reverse. I work with a lot of communities, like Aspen was one of our clients. We updated their code in 2016. Aspen's where the trillionaires are pricing the billionaires out of town, right? So they need affordable housing. And ownership isn't a problem for people who can afford to live in Aspen. So they're an example of a community that's trying to encourage housing to be affordable. So they've looked at things like inclusionary zoning, and in Colorado now, and in California and places like that, a lot of communities require developers, for example, to reserve 15% of their units as affordable housing. And it's restricted to people who earn up to a certain income level and et cetera. And that's to make sure that, in your community, you got people who can wait tables and fight fires, and you got places for law enforcement and other folks to live, not just the rich folks. In most states, you can't do that as a mandate, and I don't think you can here in Missouri either. We don't have authority to mandate that, but you could incentivize that, and I think. And again, there may be some more study needed if that home ownership policy is still a viable one with you. I think there's some legitimacy to balancing your housing stock that way. And if you studied it, you could create incentives for developers, like, for example, a density bonus, or you get more, another floor of building height or something if you reserve some units as condominiums. That's something that might fly in Missouri. You'd have more discretion to deal with that in the zoning process. Rezonings in Missouri are considered legislative. In some states, like on the Kansas side, they're considered quasi-judicial. So it's almost like a conditional use permit process. In Missouri, it's legislative. Maybe there's some discretion there to encourage home ownership with some of the units or something. But although that may be a little dicey too, just like with conditional uses. Where you do have a lot of discretion, though, is number one, development agreements, and that's where a developer would proffer a condition. They're volunteering this. You're not sitting there demanding it, but a developer might say, I understand your policy. We want to be good folks and work with the community. I actually know a lot of developers who are like that, and we'll reserve some of our units as condominiums, and we'll enter into a development agreement that sets out our conditions of approval. It recognizes that we've volunteered this, and we waive any legal challenges and et cetera, and that's something that a lot of communities do. And so with that, you have some discretion to negotiate, to make sure those, conditions, and it helps to have findings of fact and things like that are set out in the agreement and the approval, and findings of fact in your plan and other documents that document why you want to do this, and why maybe it's something that developers contribute to. So I'll talk about that a little bit with the property rights discussion, but that's where you might have some discretion. Financial incentives are another one. One thing I do in my volunteer and my so-called free time is I sit on the Lee Summit Land Clearance and Redevelopment Authority. And so we finally got our first housing project come through. And I think it went beyond our powers with property tax abatement. We have a new guy who used to be with Friley. Dave Bouchek? He works with us now. Okay. Dave's really good. He's good at putting these deals together. We had one, it was city-owned property. They had sales tax incentives and things like that. There's a development agreement that goes with that. And if you don't have to approve a financial incentive, and so you can tell developers, if you're going to do business with us like that, maybe we'll want you to reserve. We're not going to do this just for apartments. We're going to do this with projects that help us get closer to what we consider our optimum housing mix in terms of ownership and rental and so forth. And where you really have the most incentive is when you own the property yourself. Because you don't have to sell it to anybody. You don't have to, you can make whatever deal you want to make, I think, with that. And, that was another one, that this residential project that came before the city that, we had a lot of concessions. It was the city's property. I feel like I'm part owner as a citizen of Lee Summit, and so I asked for a lot of things. I got overruled by the rest of the LCRA. I was asking for things with the design. I wasn't happy with the design of it. It wouldn't have, this isn't something you would have approved under your form-based code, let me put it that way, but that's beside the point. We could have asked for affordable housing if we wanted to, and things like that, I think, since it's our property. So, you know, there's things you can do, I think, when you own the land that give you more discretion. So thanks for the question. I appreciate it. I'm glad I just happened to have a slide there that answered it. And so with housing strategies, and again, not many communities have used zoning as a tool to encourage ownership. They've more, you know, most of the time this comes up with using zoning to address affordability. And one of the reasons why is zoning sometimes works at cross purposes with affordability. A lot of communities, especially in the suburbs, have an overwhelming majority of their land zoned for only single-family detached housing, which is more expensive and it's at lower density, so you don't generate as much housing. And so just forces of supply and demand, the housing types tends to be more expensive. And so a lot of communities have done things on a reactive basis to modify their zoning regulations and make them more flexible, to make it easier to build things like apartments or multifamily or units that tend to be more affordable, and those tend to be market-driven. Others have been more proactive, either through incentives or mandates doing inclusionary zoning, where they require housing to be set aside. So, and again, some communities have housing trust funds. Their communities have used tax increment finance and redevelopment set-aside requirements for affordable housing. It would be interesting if to see what would happen if, you know, and how that would work if you applied that to like ownership or something else. Something called linkage, which I don't think you have authority to do in Missouri, but it's interesting. It's basically an impact fee for affordable housing. And I've worked with communities who've done that. Using land assembly, if you have surplus land, things like that, using that, you know, to through the private marketplace to encourage developers to build something more of what you want. And looking at your existing housing stock and just your existing supply of buildings. A lot of there are buildings here that could convert to housing for people who need it or who want to own it in a community like this. And like I mentioned, most of your zoning enabling legislation is fairly standard, but you have this one statute, 89.010, that talks about what's called Transect-Based Zoning. It's an interesting concept. Basically, it authorizes form-based codes, which is what you did a few years ago. So it gives you the ability to look at a lot of different things that are beyond the traditional purview of zoning, and you've taken advantage of that. And it mostly addresses design. You don't want your commercial projects looking like this typical suburban product. You want something that's more walkable. You want the residential that's not as garagey, that relates better to the street. Another tool is plan unit development. And again, that's a rezoning that's basically a customized project where a developer would come up with a master plan and negotiate it through the rezoning process and would get that approved. I can tell you from, you know, I updated Olathe's Unified Development Code a few years back. I'm working with Unified Government on the other side of the river here. And on the Kansas side, they use PUD a lot, and I'm sure that in Lee Summit, they use it a lot. So basically, you negotiate your approvals. The development agreement that I talked about earlier can go part and parcel with it. It's flexible, and et cetera, and you can demand a more exceptional design. It's something I got to say, and I work with a lot of communities that get into that and then they try to get out of it. I mean, that's what we did with Olathe. We did what we call composite zoning code that was more design-based like you have, because we wanted development to be more predictable. But there are some benefits. Number one, the courts here in Missouri have blessed it. You can clearly do this. It's you know, it doesn't have to occupy a lot of space in your zoning code. It's basically negotiated. You can condition cases or projects on a case-by-case basis without going through variances. Developers know how to work with it, et cetera. So, but you don't want it to be the standard here, because PUD also stands for paranoia, uncertainty, and delay. And developers like the flexibility. They hate the amount of time it takes to get through the process. Sometimes it can be expensive, it's unpredictable, and et cetera. So if you decided to do that as a way maybe to encourage some different things in the community, I think it's good to have that option. It would not be so good to make that the default. You've got a very good code, I think, for the rest of the city. The next package of regulations is subdivisions, and again, this is platting, where you divide an existing lot into multiple lots. In a build-out environment, it can come up sometimes with vacating streets and that sort of thing, and you would have some discretion in that situation to work with developers. And there's, very broad authority there. So I'm going to talk quickly now, I know I'm probably maybe running into time, about some of the constitutional issues, and the main ones are property rights, takings, due process, and there's substantive and procedural aspects of that, equal protection, and then the First Amendment can come up. So property rights and takings comes up a lot with zoning. If your regulations are so strict that people, somebody just can't do anything with their property, that's a problem. I doubt that you're going to have very many of those situations with the way your development code is written. But the other aspect of takings is known as exactions. And so everything I talked to you about, imposing conditions and those sorts of things, those can raise takings issues too, because when you're, when somebody's surrendering a bundle of their stick of property rights, like if you ask them to make a public improvement or build a park or provide affordable housing or condominiums even, or something like that. The rule in the courts is it's got to be proportionate, roughly proportionate to the impacts of that development. It can't just be whatever you came up with. The caveat to that, though, is what I mentioned earlier. If the developer's proffering it and says, we're not going to sue you, we want this to be part of our project and we want to make it enforceable, that would be a defense. And so this is an area of the law that's evolving. This is a county, and actually this case was litigated before we redid their code. This is on the St. Croix River that separates Wisconsin and Minnesota. They had lot merger requirements along the side of the river. They wanted to keep density low along the river and protect the riverside and the scenic beauty of the river. And they required, if you owned two properties, both of which were substandard in size, you had to merge them to comply with that. And that was brought. The property owner claimed that took one of those parcels because they couldn't do anything with that parcel other than merge it with the other one. So instead of building two houses, I can only build one. That went up to the U.S. Supreme Court. Justice Kennedy found that it was not a taking, even though they could make more money with two houses instead of one. So that's an important element of property rights. People aren't entitled to the maximum value they could get from their property absent regulation. They're only entitled to a reasonable use of their property. But one interesting thing about this case, and it's decided a few years ago, is one of the things that the U.S. Supreme Court looked at is the fact that lot merger is a familiar tool. It's something communities around the country commonly do, and they thought that was something that strengthened the validity of this and made it look less like a taking and more like a conventional land use control. So that's something to consider. In the Missouri case, the leading case in Missouri that approved plan unit development, that also involved proffered standards, and there was a third-party challenge to the approval of that, and the court found that because all of those conditions were reasonably related to the impacts of that development, that survived. So again, if that's a tool that this city wants to use more widely, that becomes the standard. So those are one of the ways to deal with it. With due process, there's two types. There's substantive, which means that all of your regulations have to be rationally related to a legitimate public purpose. And then with procedural, when you do things like conditional use permits, people have a right to basically have a right to make their case. So with due process, This is a very differential test. Courts aren't likely to overturn something you do in a conventional zoning ordinance unless it's so irrational. It's the same thing as just like rolling the dice or closing your eyes and picking a name out of the phone book. Beyond that, most of what you do is something courts are going to defer to. This does come up from time to time in zoning. This is a case years ago in Missouri that's always had me nervous because it dealt with a build-to line, one of those maximum front setbacks. And the way this was applied, it was applied to a gas station. And because the building had to be in the front and everything else, all your parking and all that had to be in the back, they had to put their pumps in the back. And the Missouri Court of Appeals found that, well, you can't build a gas station with the pumps in the back because nobody does it, so nobody knows how to do it. And gas stations are allowed in the underlying district. This is an overlay district that effectively doesn't allow them. So they found it was invalid and confiscatory. It was a weird case. I was very shocked at the outcome. But it's there, it's a bad precedent, and I think courts, cities could defend that kind of regulation today. Number one, we could show lots of images and pictures and examples of gas stations that are actually built that way all over the country. And number two, we know why we have these maximum front setbacks now and why they're important. But that's out there, and that's what was actually built. The two images that flank it, the one in the middle is what was built. The two images that flank it are, one is in Charleston, one's in a new urbanist community north of Washington, D.C. Both are gas stations that have their pumps in the back. So I don't know what the Missouri Supreme Court of Appeals was thinking here. With procedural due process, if it's a rezoning, if it's legislative, procedural due process doesn't apply, but for conditional use permits, good idea to have findings of fact and conclusions of law. Due process requires an unbiased decision maker. Applicants and people affected have a right to introduce evidence and to cross-examine people who disagree with them. They have the right to do that. Most people don't know that. And when I'm in that sitting there as the city or county attorney, I usually don't volunteer it, but if they ask for it, we can deal with it then. And base your decisions on findings of fact and conclusions of law based on evidence in the record. There's also an element of language precision that comes up too, that your standards should be clear enough that they're not excessively vague. They're not too open to interpretation. And this is an interesting case that came out of the St. Louis area in 1970. They required architectural review of new buildings. Somebody proposed this thing on the right in a traditional neighborhood, and the regulation said that you could disapprove it if it was unsightly, grotesque, or unsuitable in appearance. Sounds kind of vague to me. This building was denied. The property owner sued, said this is unconstitutional because you have too much discretion, and the court said, now there's an appeal available to city council, so we're going to uphold it. I can tell you in most states, and probably even a lot of decisions today would go the other way on that kind of language. It's just more discretionary than I would certainly recommend as somebody's attorney. The nice thing too about this, while due process applies with a conditional use permit or anything else that's quasi-judicial, you don't have to apply the circuit court rules of evidence. It's kind of fundamental fairness, so there is flexibility there. Equal protection comes up sometimes too. You'll have applicants say, well, you did this for the guy down the road. You have to give me the same outcome. I'll tell you that's not true. The applicants have to be similarly situated. And if there's any rational basis for treating them differently, there's not some pernicious reason for that, like racial discrimination or something like that, then courts are almost always going to defer to the local government. But equal protection does come up from time to time. And courts take a hard look at this only if there's something pernicious behind it. And then the First Amendment comes up a lot, and I'll just talk about that quickly. There's a U.S. Supreme Court case a few years back, called Reed versus Town of Gilbert that dealt with content neutrality for sign regulation. So basically, the requirement is you regulate signs by the physical form of the signs, like you do with buildings, in your zoning regulations, and not by what the signs are trying to communicate. It also comes up with adult businesses. Courts actually require that you have enough land area zone where somebody could do one of these things. So that comes up too. And then there's federal legislation. So there's a few instances where the federal government has gotten involved. Zoning is traditionally a local function. It's assigned to cities and counties and other local governments, but we now have, in the 60s, the Fair Housing Act was passed, and that's been applied to communities that have tried to exclude things like group homes or housing in a way that makes those communities inaccessible to minority groups. Telecommunications Act of 1996, has some requirements for how we regulate things like cell towers, and now there's FCC rules that address the small cell and 5G type of infrastructure. And then RLUIPA, the Religious Land Use and Institutionalized Persons Act, requires us to treat religious land uses the way we would treat any other assembly type use, and we can't have regulations that are too strict for them. So there's some federal legislation that applies now too. So anyway, I got through this. Basically, you have a lot of flexibility in Missouri, even though your legislation is older, and there are ways to apply that to your new policies. But this is an ever-changing area of the law. So anyway, yes, sir. A couple of questions?
Yeah, one, seems like the bottom line here is that while there are constraints as a third-class city and being in Missouri, there's a great opportunity for creativeness, being creative in how we apply these things, and maybe try to push the envelope a little bit. And then we may bump up against a wall when we do that, but it's an opportunity that we should be taking. And I appreciate that.
Good.
Thank you.
You bet. I concur. That's a good way of putting it. And you've done that. Last couple of years, you updated your code and incorporated a lot of new concepts, and that's certainly possible. So I think that's a great way of putting it. Yes, sir.
So I wanted to get your thoughts on this. You alluded to some non-conforming pieces. I don't know if we touched much on that, but just to give an example, in our R1, I believe it's R1A zone, single family, we have some, they're multi-unit. They weren't permitted at the time. They are now, housing people in basements. They might fall under an accessory dwelling unit at this point, but they weren't done to code. They weren't done in a permitted way. What is the city's option legally to enforce the zoning in that zone that has now gone out of that use case? Can we take action immediately, or do we have to wait for the property to change hands or for there to be a renovation permit? What could trigger us enforcing the zone?
Okay. If it was configured that way before the restrictions were put into place, it could be non-conforming, and that all depends on the specific language of the ordinance.
Sure.
But it could be non-conforming. And, you can keep them the way they are. You can say, the way you're configured now, that's the way you have to stay, right? That's what a nonconformity is. You can't expand. You can't get more intense inside the four walls of your building. Or you could say, and there's other ways to deal with nonconformities too. There was a land use attorney when I was in law school in Chapel Hill who he wrote a book on this, and his adage was always, nonconformities never go away, they just get worse and worse. So some communities allow the nonconformities to expand, and sometimes that's through like a discretionary review process. So you could say, if you want to add more dwellings, you can do that, but you got to get conditional use approval, and you've got to come in and talk to us and maybe mitigate some of your impacts and things like that, and the things people are complaining about. So there's that. What you can't do in Missouri, and you can do in some states, is amortize. Some states say, in 5 years, you got to come into compliance, and we'll let you recoup your investment, but after, Missouri doesn't allow that.
What if the non-conforming use predates, I mean, it was, say it was always zoned single-family, and they just put an extra residence or an extra dwelling unit there? At some point, say in the 1990s, they did
Right.
this, and now we become aware of it.
Oh, that's a good question, and I've had that come up before too, and people will try to argue, well, I'm in violation, but I've been in violation for 20 years.
Right.
What are you doing? And the courts of Missouri said no. That just makes it worse. You've just been in violation for 20, you've got 2 decades of violation now, so that's worse. It's not something where we allowed that to happen. This came up, I think there's a case out of Columbia where somebody tried to argue, and it was a situation like this. It was a rental type of situation, and the guy had gotten a business license, actually, from the city, and tried to say, well, the city's now has stopped. You know, you guys kind of gave us permission to do it. And the court said, no, the business license isn't zoning approval. You know, that's just how we tax things, but you've been out of compliance for a long time. And now that we've discovered the violation, yeah, you've got to come into compliance with what's now the current regulations, because you've been illegal for a long time.
And what is the mechanism for doing that?
You bring an action to enforce, you know, the zoning ordinance. Typically, you issue a notice of violation. You explain to the property owner why they're in violation. They have an opportunity usually at that point to appeal to your Board of Adjustment. And then, you know, they may have a hearing on that, and they make findings of fact too that courts have to defer to. And if they're found to be in violation, then, yeah, you can bring an action to shut them down, an action to abate them, or et cetera. So there's some legal remedies that are listed in the statute once you've found someone to be in violation.
Thank you.
You bet.
Any further questions? Seeing none, thank you, Mark, for the presentation. Thank you, Sarah,
Thank you.
for having this. And I want to thank the commissioners, Commissioner Wood and Commissioner Shekels, for showing up as well. I appreciate it. We are adjourned. And we will
you.
begin up 7:05. Let's go 7:05. We'll give everyone a couple minute break here, 7:05.